guys, Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's program. On today's program, we're continuing with our new series entitled The Apportionment Black Belt. And today we're in session number 2. And I have a fascinating program today that I consider to be appropriate for advanced users, advanced QMEs. And I hope this that doesn't sound daunting to those of you who may be newer QMEs, but we're going to get into some topics today that really consider some deep philosophy on apportionment. And before we get into today's topics, let's just review where we've come from so far. Today we're in session 2, and in our first session, which was last week, we talked about the historic context of the apportionment laws as they now exist. And those apportionment laws have to do with Labor Code 4663 and 4664. And we put these new apportionment laws in the context of the historic development of apportionment between 2004 with the passage of Senate Bill 899 and today. And apportionment radically changed in 2004 as the legislature at the time scrambled to address what they considered to be skyrocketing costs. That was the phrase they used at the time, skyrocketing costs of administering workers' compensation claims. And one of the ways that the legislature sought to attack skyrocketing costs was through the enactment of new laws relating to apportionment. And I'm sure you can imagine that apportionment is one of the main drivers of costs of workers' compensation claims. So they enacted new laws, Labor Code 4663, 64, and they repealed former Labor Code 4750, and that leaves us where we are today with apportionment now based on causation. So we reviewed in their entirety Labor Codes 4663 and 4664. And today what I want to do is I want to talk to you more about these labor codes. And we're going to dissect these labor codes with a fine-tooth comb, looking down on them on a word-by-word basis. It's amazing. You know, these labor codes have been scrutinized under a microscope now ever since their enactment in 2004. And every single word in each of these codes is critical and contributes to the overall enforcement of these codes as relates to apportionment. So I want to dissect these codes today with a fine-tooth comb, and I want to focus specifically on one of the major concerns of the legislature at the time, and that was that we as qualified medical evaluators, when it comes time to provide our opinion on the apportionment of the permanent impairment, that we take a hard look, that we take a focused look, that we take a concerted and concentrated look, and that we put some effort toward developing the history as relates to prior industrial injuries. This legislature is concerned that employers only pay once and that employers do not duplicate payments to the same examinee for the same injury and for the same impairment. So the term prior industrial injuries is present in some fashion and form in both of these labor codes, 4663 and 4664. And I want to share with you today the subtle and profound nuances between these two codes, 4663 and 4664, as they relate to the apportionment of permanent impairment when an examinee presents to us with a history of prior industrial injuries. And let me ask you, isn't it true that many examinees in the workers' compensation system have a history of prior industrial injuries? Well, prior to the enactment of these two new labor codes, examinees could get duplicative and multiplicative payments for the same injury, for the same body part, and for the same disability over and over and over again. And one of the ways to address skyrocketing costs was simply to have us focus on a history of prior industrial injuries and provide an apportionment opinion that allows the employer to be liable only for the portion of the permanent impairment that's directly due to their injury, the industrial injury that occurred on their premises. They don't want to be responsible for duplicative and multiplicative and repeat payments, compensation, for the same injury, for the same impairment over and over and over again. And that makes sense. So the legislature asks us now to take a hard look at prior industrial injuries. And I want to show you exactly how to do that using two populations of examinees. Examinees who have a prior industrial injury. Okay, there is a prior history of industrial injury. And when you think about examinees who have a history of prior industrial injury, what are the possible outcomes for that examinee? The possible outcomes are finite. For example, we can have an examinee who goes through treatment, medical treatment, and is declared to be permanent and stationary with no permanent impairment. They have an industrial injury, but they have no permanent impairment. So that particular industrial injury is not subject to apportionment because there's no permanent impairment. But in the event of a subsequent injury, how do we consider that prior industrial injury in the apportionment determination? We're going to talk about that. So that's one type of examinee. Second type of examinee is an examinee who's declared to be permanent and stationary. They are determined to have permanent impairment, and there's an apportionment determination for that examinee, and that examinee receives a permanent disability award by stipulations and award. They receive a formal permanent disability award. Okay, how do we handle that examinee in the event of a subsequent industrial injury? Okay, they have a prior industrial injury. This is the prior, for which they were awarded permanent impairment or permanent disability. And then they have a subsequent injury. How do we handle the prior industrial injury when it comes time to address apportionment for the subsequent industrial injury? We'll talk about that. So that's the second population, or the second possible outcome. The third possible outcome is we have an examinee who has an injury. They receive medical treatment. They have a qualified medical evaluation report or a permanent and stationary report issued by the primary treating physician, and the case is settled by way of compromise and release, a C&R. So we have a report from either the primary treating physician or a qualified medical evaluator that addresses permanent impairment, but the examinee settles their case by compromise and release, okay, which is different from a stipulation and award. So how do we handle this examinee who then has a subsequent industrial injury? Okay, this is the prior industrial injury that's settled by compromise and release. Now in the event of a subsequent industrial injury, in the event of permanent impairment, how do we handle the compromise and release? Is it the same as a permanent disability award? Are they different? Should they be processed differently? Do Labor Codes 4663 and 4664 apply to these two situations differentially? Well, that's our mission and our motive and our driving purpose today, is to resolve these difficult questions that occur in our practices actually quite frequently. So we're going to talk about some things that are very commonly encountered in your QME practice, and we're going to handle them once and for all. So I'm going to go ahead and assemble my references and resources, and if you've not had a chance to download a copy of Labor Code 4663 and 4664, it is included today as a link to today's blog. So go ahead and download that. I think it's important that you be able to put your own eyes on these references as we go through today's discussion. So I'll give you a minute to do that, and I look forward to being right back here with you in just a couple minutes as we continue our new session, the Apportionment Black Belt. And today we're in session 2, the Compromise and Release. Okay, I'm back with you now and have my references in order. And we're going to go over a couple of things today. I want to begin by reviewing key points in Labor Codes 4663 and 4664. And I want to talk to you today about the differences between a stipulation and award and a compromise and release. And I'm sure you're familiar with both of these terms. With a stipulation and award, this is a formal proceeding where the permanent impairment rating and the permanent disability is etched in stone and forever recorded. And the insurance company has an ongoing relationship with the claimant, whereas with a compromise and release, the case is settled for some agreed upon figure that the parties get together, discuss, and are able to agree upon, and the case is closed forever and ever. Compromise, and then the case is released. So I want to talk to you today about the differences between those two outcomes and how those differences affect the apportionment determination in the event of a subsequent industrial injury. Okay, so let's just review key points of 4663 and 4664 as they relate to these types of examinees who have had a history of a prior industrial injury. Okay, we're talking about examinees who have a history of a prior industrial injury. Okay, so 4663, let's go straight to Section C. It says that a physician, and you're familiar with this one, a physician shall make an apportionment determination by finding what approximate percentage of the permanent disability was caused by the direct result of injury arising out of and occurring in the course of employment. That's one thing. And what approximate percentage of the permanent disability was caused by other factors, both before and subsequent to the industrial injury, comma, including prior industrial injuries. So here the legislature turns our attention to prior industrial injuries. They specifically cite prior industrial injuries. They don't specifically cite prior sports injuries. They don't specifically cite prior auto accidents. They don't cite specifically prior permanent impairments. They don't cite specifically prior birth defects, anomalies, defects, deformities. The legislature is particularly concerned that we turn our attention in apportionment determination to prior industrial injuries. So there's the reference to that in Labor Code 4663. 4664 says, if the applicant has received a prior award of permanent disability, it shall be conclusively presumed that the prior permanent disability exists at the time of any subsequent industrial injury. This presumption is a presumption affecting the burden of proof. Okay? So what does that mean? That means that if the examinee had a prior industrial injury and they received an award of permanent disability, in other words, they settled this case by stip and award, stipulations and award, the permanent disability shall be conclusively presumed to exist at the time of the subsequent industrial injury. So what this means is by the time of the subsequent industrial injury, the examinee was already damaged goods. Whether or not the examinee was able to rehabilitate himself medically or not, on a legal basis, on an administrative basis, the law says that prior permanent disability continues to exist into perpetuity. Period. End of statement. It's the law. Okay? Now, and doesn't that make sense? Doesn't that make sense? That's consistent with the term permanent disability award. How permanent is permanent? Is permanent temporary? No, permanent is presumed to be permanent. And how can a person with a permanent disability award then go on to claim medical rehabilitation at 6 months, 1 year, 2 years after the settlement of the case by stip and award. In the old days, prior to passage of Senate Bill 899, an examinee could demonstrate medical rehabilitation, but Labor Code 4664B changed all that. And the law now says that if you had an award, you bought the label of damaged goods. You already have a bad back at the time of the subsequent injury. You already have a bad shoulder at the time of the subsequent injury. You already have problems, pain, positive objective findings, limitations in activities of daily living. If you have a prior permanent disability award and everything that entails continues to exist and persist administratively and legally into perpetuity. Now, the next sentence in Labor Code 4663 says, this presumption, in other words, this conclusive presumption, is a presumption affecting the burden of proof. Now, what does that mean? We're going to talk about that as we go. It might seem at first glance that what that sentence says is that the conclusive presumption of the existence of the permanent disability is a presumption affecting the burden of proof. In other words, it can be rebutted with enough evidence to show a medical rehabilitation. It would seem that that's what that sentence refers to, and that's what that sentence means. But in actuality, case law has demonstrated on multiple occasions that that's not what that sentence means. And we'll talk more about what that sentence means. But the point that I'm making by bringing it up now is simply to reinforce the fact that the conclusive presumption is written in stone. It's conclusively presumed that a prior permanent disability exists and persists, period. There's no way around it. It's the law. Okay? So what's interesting is that Labor Code 4664 relates to those who have had a prior stip and award. Does it apply to those who have had a compromise and release? They don't have a formal permanent disability award, but they do have a permanent impairment rating written by the qualified medical evaluator or the primary treating physician that then results in a compromise and release settlement of the case. Is that the equivalent under 4664 of a prior award of permanent disability? We're going to talk about that as we go. Or is it more likely and more appropriate that compromise and release cases are resolved under 4663, which says that we're supposed to look at the approximate percentage due to the injury, the approximate percentage due to other factors, including prior industrial injuries. We're going to resolve this dilemma once and for all. And I need to tell you that I used to handle compromise and release cases exactly the same as permanent disability award cases. I figured that if they settled their case by compromise and release, that monetary settlement of the compromise and release was based upon a qualified medical evaluator's report or the primary treating physician's report, which describes some level and some factors of permanent impairment. So I treated them the same, but according to case law, they're not handled the same, and I'm going to share that with you here today. Okay? So a couple key points now about these 4663 and 4664 nuances. Number one, under Labor Code 4664 now, the applicant is not permitted to show medical rehabilitation from the disabling effects of the earlier industrial injury or injuries. It used to be that they could show medical rehabilitation, and I'm sure you had those cases. Examinee would say, yeah, I had a prior workers' comp case, I had an injury, I had treatment, and I received an award. But after that, in the next year, my back started to get better. I started to go to the gym and I lost weight. And in no time at all, I had no problems with my back. I never been to any doctors. I've not had any treatment, no chiropractic care. I was rehabilitated. until I had the subsequent injury. And the prior permanent disability award could disappear with a successful showing of medical rehabilitation. Well, now under 4664, that's gone. So what this does is this abrogates or disappears the line of cases that had allowed an injured employee to show he or she had medically rehabilitated from the effects of an earlier injury at the time of a subsequent injury. So when you have examinees who come to you and they have a prior award of permanent disability, remember that that prior permanent disability exists and persists. So when they tell you about back pain, don't be surprised. You know they already had back pain. When they tell you about limitations and activities of daily living, don't be surprised. They already had activities of daily living limitations. The employer is only responsible for the worsening of the pre-existing permanent disability. You need to separate that out for the parties. Okay, number 3, the presumption affecting the burden of proof means that the burden of proof is on the defense to demonstrate an overlap between the prior permanent disability and the current disability. This is critical. This is critical, and we're going to have some examples of this and discuss this in more detail in our next session. But the point of it is, in general, that if a prior award, of permanent disability exists and persists, okay? Let's go like this. This is the prior award of permanent disability. It exists and persists. Well, if the examinee has a subsequent industrial injury with a permanent disability, the burden is on the defense to show that these two disabilities have an overlap. And the employer is not responsible to compensate for the overlap. Okay? So the prior permanent disability exists and needs to be apportioned out of any current disability, but the burden is on the defense to show that indeed there is overlap or exact matching or some matching, some overlap of the prior disability with the current disability, and the extent of the overlap then can be apportioned out. Now sometimes it's quite difficult to demonstrate overlap, especially when the formulation for one permanent disability award is completely different from the formulation of the current disability award. This happens all the time in cases that involve the prior permanent disability rating schedule from 1997 compared to the current permanent impairment schedule using the AMA guides. Okay, very difficult to show overlap, but the burden is on the defendant to show the overlap. If the defendant is unable to show overlap, then the current disability continues on unapportioned, and the examinee would receive the entirety of the disability rating, not subject to apportionment. Okay? So overlap, let's just define overlap. Overlap is whether two or more injuries or conditions cause some or all of the current disability. And I have several cases I want to share with you regarding overlap. Cases wherein overlap could not be established results in a finding of no apportionment, because the defendant failed to meet its burden. In this case, the applicant gets compensated for the entirety of the permanent impairment award. Okay, and I'll share with you several cases on that. Okay, so let's talk about the differences between a stipulation and award and a compromise and release. And this is critical information for us to be aware of because we get these cases, these kinds of cases, all the time. Okay? So how do we handle them? Let's talk about that now. So let's talk about the compromise and release. What is a compromise and release? Well, it's important for you to know that there are approximately 200,000 workers' compensation claims filed annually on an annual basis. And that's been a steady average over at least the past decade. Well, greater than 50% of all of those cases are resolved by compromise and release. The other smaller fraction of cases, less than 50%, are settled in the courts at the Workers' Compensation Appeals Board and settled in front of judges, okay? Many times for a stipulation and award. So greater than 50% of cases, the preponderance of cases, settle by compromise and release. And the settlement of cases by compromise and release is critical for the successful functioning of the workers' compensation system, because there's no way that the WCAB can handle the whole volume of 200,000 claims filed every year. It would bring the system to a grinding halt. So thankfully, these cases are able to be settled by compromise and release. Now, why is it, and what are some of the reasons why a case would settle by way of a compromise and release, and what are some of the reasons that would drive a case to be settled by a stipulation and award? Well, there's many obstacles to resolving cases by formal stipulation and award, which would then favor the settling of cases by compromise and release. So what are some of those obstacles? Well, how about a disparity of evidence regarding the nature and extent of the employee's disability? How about disputes as to how to rate the permanent disability described in one or more medical reports? What about questions regarding the legal substantiality of the existing medical evidence? What about questions about how much, if any, of the employee's permanent disability is related to his or her industrial injury? In other words, there's many barriers and hurdles to overcome, not all of which are successfully overcome, that allow cases to be settled by stipulations and award, thereby favoring the settlement of cases by compromise and release. So what are some factors that may motivate parties to settle by way of compromise and release? And as we go through these, I want you to think about your cases and ask yourself, are any of these factors or any of these motives present in your case? Okay? How about undisclosed issues regarding the injury, regarding employment, regarding the statute of limitations, regarding insurance coverage, or even outright fraud? These are some things. If you have a questionable industrial injury, AOE, COE is not clear, we have an unwitnessed incident perhaps, with a delay in reporting and the other party is objecting to even the occurrence of an industrial injury, this could be a case that could then be settled by compromise and release, and the parties can go both on their merry way, happily ever after, knowing that the matter was quickly and inexpensively resolved. How about the applicant's desire to extricate him or herself from the workers' compensation system? Sometimes applicants say that. They say, I just wanted to be done with that. How about the applicant's wish to avoid the delays inherent in obtaining a decision or the risks inherent in litigation? How about applicants' non-industrial health factors? The defense raises the contention or the objection that applicant already had same similar condition for the past 20 years, and it becomes a point of contention. Let's just settle this case quickly and inexpensively by compromise and release, because there's no way we're ever going to gain the agreement to settle by stipulation and award. How about applicants' immediate financial needs or desire for a lump sum of money? It's interesting, compromise and releases are settled by lump sum of money. whereas permanent disability awards are settled by weekly payments over the duration of time that it takes to fully pay off the permanent disability award. So small payments versus lump sum payments. How about the defendant's wish to avoid the risks and costs of litigation? How about the defendant's desire to close its file? Compromise and release allows the defense to close its file, thereby eliminating its need to maintain reserves for possible future benefits if the case were to be reopened, eliminating its cost of maintaining the file for the lifetime of the employee in the event of an award for future medical treatment, and reducing its risk of penalties. So there's many motivators that push the defendant to settle by compromise and release, probably not the least of which is that it allows them to close the file and to put that thing in archives and put an end to the bleeding of the money. Okay? How about defendant's desire to keep its costs down in multiple party cases or cases that are likely to entail multiple or extended proceedings, which would simply drive up the cost of administering the claim? How about the defendant's desire to settle around liens? How about third-party recovery issues, such as recovery through an automobile insurance policy, such as coverage through a long-term disability policy, such as recovery from Medicare, such as recovery from state disability, as an example. So there's many motivators that push the settlement of cases by way of compromise and release. And I know you know this to be true because we get these cases all the time. Sometimes we ask ourselves, well, why did they settle the case by compromise and release and give up their ability to get future medical care? Well, maybe it's because they wanted a lump sum payment and they were willing to forego the opportunity to receive treatment in the future in exchange for a lump sum payment. Many examinees find themselves in financial difficulties, and that lump sum payment is a motive to settle by CNR. So there's many motives to settle by CNR, and there's many barriers to settling by stipulation and award that then drives the settlement of the case towards a compromise and release. And as I said, more than 50% of cases are settled by compromise and release. Okay? So before we talk about how to handle apportionment in a compromise and release, let's just go over some of the differences between a stipulation and award and a compromise and a release. So number one, a compromise and release closes the case down and the parties move on, whereas with a findings and award, the file remains open and there's an ongoing relationship between the applicant and the employer. With a permanent disability award, the relationship continues and is ongoing. So for example, they're going to receive permanent disability payments for months, years, possibly even a lifetime. They retain the ability to reopen the case within 5 years. And then there's always the applicant dipping back into the file with ongoing future medical care visits. So the relationship continues, whereas with a compromise and release, once that's signed, the relationship is over. That's why they call it a release. Compromise and release is paid in a lump sum. Permanent disability, on the other hand, is paid out over time, the reason of which is to assist the injured worker in his adjustment in returning to the open labor market. So many times this is the main driver in itself. Some examinees would far rather receive a lump sum payment than smaller payments over a longer period of time. Finally, in a subsequent injury, and this is what we're going to see, and this is one of the take-home messages of today's program, apportionment of the permanent impairment in cases where there's a prior award, prior stipulation and award, is handled under Labor Code 4664, while a prior compromise and release is handled under 4663. So what does that tell us? It tells us that a compromise and release does not qualify as an award of prior permanent disability under Labor Code 4664. So now I want to share with you a case known as the Pascoe-Otto case that perfectly illustrates these principles. So we'll take a quick break right here and look forward to being back with you here in just a few moments as we continue to develop the nuances between Labor Code 4663 and Labor Code 4664. Okay, I'm back with you now, and to conclude today's discussion on apportionment and the compromise and release, I want to share with you an important case known as the Pascoe-Otto versus Hayward lumber case. And this case provides precedent for us in the way that we handle apportionment in those cases that involve a prior compromise and release. And the prior compromise and release is to be distinguished from a prior award of permanent disability. So we're going to see that the compromise and release is apportioned under Labor Code 4663, and a prior award of permanent disability is apportioned under Labor Code 4664. So let me share this case with you here very briefly. Eric Pascoe-Otto suffered an industrial injury in 1998. He suffered an injury to his lower back, and he had a surgical procedure on his lower back, and after time and treatment he had an agreed medical evaluation, and the agreed medical evaluator found Mr. Pascoe-Otto to be permanent and stationary and found him to have permanent disability. This was in 1998 when we talked about permanent disability versus permanent impairment. So he was found to have permanent disability. And his disability included slight pain, slight sacroiliac pain, that increases to moderate sacroiliac pain with heavy lifting and repetitive bending. He had work restrictions of being precluded from heavy work and should not lift more than 30 pounds. Okay? So the agreed medical evaluator described some of the factors of disability. He described the subjective factors of disability as slight to moderate sacroiliac pain. He described the work restrictions as preclusion from heavy work and no lifting greater than 30 pounds. So the agreed evaluator talked about and discussed the factors of disability. Well, Mr. Pascoe-Otto settled his case by way of compromise and release. For whatever reason, it did not settle by stipend award. It settled for compromise and release. Now, before we go on to subsequent injuries, it's important to you know that these factors of disability of slight sacroiliac pain and the work restrictions that I described factored out to a 30% disability rating. Okay, so just remember that briefly. So he was found to be a qualified injured worker. He went through vocational rehabilitation to become a truck driver. Okay? To become a truck driver. So the first injury was in 1998. In 1999, he was declared to be permanent and stationary with a permanent disability award. Later in 1999, he completed vocational rehabilitation. Okay? And he settled his case in late 1999, by way of compromise and release. Okay? So, was evaluated by the agreed medical evaluator in late 1999, settled the case by compromise and release in late 1999, completed vocational rehabilitation in late 1999, and then in late 1999, he applied for a job as a trucker. He had a pre-employment physical, all within the same period of time. In applying for the job as a truck driver, he had a pre-employment physical administered by a medical doctor. He said that he had been released to do heavy work. He said that he had no recent low back pain whatsoever. So on the one hand, he's settling his case by way of compromise and release based on the report of the agreed medical evaluator, and then in the same period of time, he's applying for employment as a truck driver and reporting to the medical doctor on pre-employment evaluation that he has no recent pain whatever, and he's been released to do heavy work, that he's been working out at the YMCA lifting weights 5 times a week with no pain or symptoms. On that basis, they hire him as a truck driver, okay, doing heavy unloading of doors and construction materials, okay? Well, very shortly thereafter, a year or two later, he has another injury to his lower back from lifting these heavy materials. And then shortly after that, in 2002, he has another injury again to his lower back. So he had the first injury in '98, settled by compromise and release, a subsequent injury in 2001 with a new employer, and then another injury in 2002, also with the same employer, Hayward Lumber. Okay? Well, with regards to the injuries with Hayward Lumber, he was found to be permanent and stationary. This is in 2004, right after the passage of Senate Bill 899 and the new changes in apportionment laws. The evaluator found him to have disability involving frequent, slight, low back pain, increasing to moderate low back pain with heavy lifting and repetitive bending. He was precluded from heavy work, and he has a 30-pound lifting limitation, and he should avoid repetitive bending. This rated also at 30% disability, exactly the same rating as the prior rating would have rated had it gone through stip and award versus a compromise and release. Interesting. So obviously, since this evaluation of the subsequent 2 injuries took place after the passage of Senate Bill 899, the apportionment to the prior injury became an issue, because the new law on apportionment says that if the examinee has received a prior award of permanent disability, that disability is conclusively presumed to exist. And so apportionment became an issue. Okay? So how was this resolved? It went through the appeals board, and eventually it came to the all of the appeals board for an en banc decision. And I want to share with you the conclusions of this en banc decision. En banc decision are decisions that establish precedent for future cases. The Workers' Compensation Appeals Board concluded that an order approving a compromise and release agreement, which was related to the 1998 injury, without more, is not a prior award of permanent disability within the meaning of Section 4664. So they're not the same. I used to consider them to be identical, okay? But according to the Workers' Compensation Appeals Board, they're not the same. And so therefore, if a compromise and release is not the same as a prior award, then the compromise and release is not apportioned under 4664. It must be apportioned under 4663. Okay? So they're not the same. So what does that mean? Is the prior injury relevant when it comes time for apportionment? It is. It is. It's relevant under 4663, and I'll show you how we handle it. Okay? Next conclusion from the en banc decision. Okay? When there is no prior award of permanent disability within the meaning of Labor Code Section 4664, the medical reports and other evidence relating to a prior industrial injury settled by a compromise and release may be relevant in determining whether any of the permanent disability found after a subsequent industrial injury was caused by other factors under 4663. Interesting. So the prior compromise and release case is based upon medical reports, generally based upon a permanent stationary report of either a qualified medical evaluator or the primary treating physician. In those reports, the doctors describe the factors of disability, or they describe the impairment. Those descriptions can be relied upon for apportionment in the case of a subsequent injury. So you can opine the complete spectrum of the range that the prior injury had been completely medically rehabilitated and has no bearing at all on a subsequent injury. In other words, apportionment to other factors is 0%, even considering the prior industrial injury. Or you could treat it exactly as if it's a prior award of permanent disability. In other words, you could opine that this injury significantly contributes to the current impairment. In fact, could be causing as much as 100% of the current impairment due to 100% overlap of the current impairment with the prior impairment. So you can opine anywhere along that range, but we don't apportion it under Labor Code 4664. We apportion it under 4663 as an other factor, So always request and always seek and always ask about the prior industrial injury, and seek those records whenever possible, because they could contribute to your opinion on apportionment. Okay, and then finally, and this is fascinating, and this leaves the door open for those examinees who claim a medical rehabilitation. It says that the concept of medical rehabilitation from a prior industrial injury remains viable under 4663. In other words, the examinee could say, I was totally rehabilitated, and you could accept that. You could accept that if you believed it to be true, and if there is substantial evidence to prove that indeed there was a medical rehabilitation. You could accept that. However, even if an injured employee has medically rehabilitated from a prior industrial injury, this does not necessarily preclude a prior industrial injury from being an other factor causing the employee's current disability. Okay, so even if the examinee claims a medical rehabilitation, you could still opine that that prior injury weakened the body part, contributing to the current disability. In other words, again, you can opine across the spectrum, all the way from 0 contribution to the current disability to 100% contribution to the current disability. And that is the Pascoe-Otto case, and this case is included in your materials for today's discussion. So doctors, let's conclude today's discussion. We went over many things. And that is that in the course and scope of our practice as qualified medical evaluators, we're going to encounter over and over again examinees who've had a prior industrial injury. Now, when an examinee has a prior industrial injury, there's only 3 possible outcomes to that injury: a no impairment and a discharge from care outcome, a compromise and release settlement outcome, or a stipulation and award outcome. All of these can contribute to your apportionment determination under Labor Code 4663. All of these can be considered an other factor that, if in your opinion it contributes to the current disability or impairment, you can apportion to this other factor these prior industrial injuries under 4663. Well, in those cases where the examinee receives an award of prior permanent disability, those are apportioned under 4664. And the law takes a firm, hard stance and says that that impairment or that disability is to be apportioned out of the current disability. The only difficulty then becomes improving the overlap between the prior disability and the current disability. It's the burden of the defendant to prove the overlap, and then any overlap can be apportioned out, and the employer is not responsible for that. So doctors, this is a lot, but you're going to be encountering these in your next 5 cases, I guarantee it. And I want you to keep these things in mind when it comes time to provide your opinion on permanent impairment, and then also on the apportionment of the permanent impairment. So I hope this helps you and gives you some instruction and some direction in how to handle these cases. And we'll talk more and we'll develop this theme more in our very next session, but in today's session we're simply laying the foundation as to how to handle those cases that involve prior industrial injury, and the case law is very clear as to how we are to handle those. So doctors, I hope this helps you. So I want to conclude today's program by saying thank you for joining me here today. I look forward to being with you on our very next program. And for now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.